Mr. McKinney, do you?
Can you hear us, Mr. Switek?
I can hear.
Good. Yes,
I
sir.
also represent Mr. Wilson.
Okay, good. So, Mr. Switek, as far as Mr. Wilson's case,
Your Honor, I represent Mr. Wilson on some of his cases. And if I can straighten something out,
please.
on the BOP case, I think it's 2021, 1201, we filed a notice of appearance on that. At the same time, we initially got into this case. It was back in September. And for some reason, that case kind of got lost in the system. And even though I continued it last week when we were down there, no action was taken. And I think the public defense was listed as attorney of record. So I refiled a notice.
Okay. Mr. McKinney?
I'll defer to Mr. Switek and Madam Clerk as to which cases Mr. Switek represents Mr. Wilson on.
Okay.
In any case, I think the BOP case needs to be continued to May 13th in the other cases. There's discovery that's still outstanding on a lot of these cases. On some of these cases, the state hasn't even filed information yet. We don't have discovery on the BOP case and several more.
Judge, I believe the intent is to package all of his cases and place them on the May 13th docket. The court just saw him on arraignment on some other cases.
Right. Mr. Wilson, one of the reasons why I brought you back today was to make sure that you and Mr. Switek were on the same page as far as your cases. So do you understand what's going on with your cases?
Yes, sir, I understand.
Okay. So I'll see you on all of your cases no later than May 13th,
Yes,
okay?
sir.
Thank you. Thank you, Mr. Switek, and congratulations, sir. Yes, sir. Yes, sir. Mr. Newland, you're here for
Yes, sir, thank you.
Mr. Preston, I take it?
Yes, Your Honor. Good afternoon.
Okay, wait, let's get Mr. Preston, he's coming out.
Yes, sir.
Mr. McKinney, why is Mr. Sergeant back?
Judge, there's an issue after we take this
Okay.
individual, then I'd like to address it.
Good, thank you.
Joshua Preston.
Mr. Preston, Mr. Newland, who is counsel with Mr. Kilpatrick, is on Zoom, okay?
How you doing, sir?
Hey, good afternoon, Mr. Preston. Judge, I believe the intent was to ask for a continuance today. Mr. Preston has a case that we're working on in Santa Rosa County. He's got a couple cases we represent here in Okaloosa County, and he also has a couple of new charges. One that I believe is, he was just arraigned on the 14th of this month and is scheduled, I believe, your May pretrial court date. I think the goal would be to see what we can do to wrap everything up together. If the court would permit a continuance to your May, I believe it's May 13th
Yes, sir.
date, that would be our request, Judge.
Can I see about getting a bond reduction to get my stuff reinstated?
Yeah, I will, I'll pass that on to Mr. Patrick. He's out of town today. He's coming back tomorrow. So I'll put a note on his desk, to investigate motion for bond, your requested motion for bond, reinstatement.
Okay, how do I get a hold of y'all?
Via telephone, but I can have him schedule an interview with you up at the county jail.
Okay.
Thank you. Thanks, Mr. Newland, I appreciate it.
Yes, sir.
Sir. Thank you, Mr. Preston. I'll see you no later than May 13th on all your cases. If a bond motion is filed, then I'll see you then.
Okay, thank you, sir.
Thank you. Thanks, Mr. Newland.
Thank you for your time, Judge. Good to see you.
Good seeing you. Mr. McKinney?
Judge, may we address Mr. Sargent?
Certainly. Mr. Sargent, come on up. I didn't think I'd be seeing you this soon, Mr. Sargent.
Judge, and when he met with his probation officer, they gave him the form to come back and register as a convicted felon. Adjudication was withheld in his case.
Right.
So I don't believe that that is something that he needs to do downstairs. I just happened to see him walking in the front door and kind of intercepted him.
Good.
But that does bring up an additional question that probation had as they were looking at the agreement related to one of the terms is no access or possession of any social media accounts. So
Yes, sir.
they wanted some clarification on what that meant. So that would obviously include all your classic social media sites like Facebook, Twitter, anything where you are communicating with people. I think that if we carved out an exception for YouTube so that he can watch YouTube videos and Steam so he can play games.
Steam?
Steam, S-T-E-A-M, it's where you download games and play them.
Okay.
I think that that's going to fit.
Okay,
Mr.
so how does
Sargent?
probation, I mean, how do they do that? I understand their concern.
And then-
Traditionally, we say you can't have any internet access devices.
Correct, and I believe that if we stipulate on the record that probation has the ability to search his devices, then that would suffice from probation's point of view to make sure that he is not communicating, sending messages to other people. And I think that that would suffice to what the state was attempting to craft here, to make sure that there's no possibility of him sending any messages to any other people like that.
Okay. Mr. Sargent, do you agree to that?
Yes, Your Honor.
Okay. So your probation, you can't access any internet sites other than YouTube or Steam?
Well, I believe social media, if we say no internet sites, and that kicks in all sorts of different things, because at his day program, they have a computer lab. So I believe it would be better to just define social media
Social media.
within the plea agreement to be any of the classic social media sites, with an exception for YouTube and the Steam, S-T-A-M, which is just online gaming where they download games.
Okay.
Sure.
Cyclone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Pritchard Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated,
But
with
it's
24
specific enough
years of
where
local
you know
service.
what you cannot do and what you can do. So you cannot access Facebook, X, formerly known as
Twitter.
You cannot access Snapchat. You cannot access Instagram. you cannot access TikTok. You can access YouTube and Steam, okay? Probation's given the power to search any of your internet devices to see if you're violating any of those. So they can look over your shoulder, not literally, but they can look at your machines and see if you've done any of those things, okay?
And Judge, just to clarify, that would be any of his devices and any electronic devices in his household?
Yes, sir. Good.
Yep.
Thank you. Thank you, Mr. Sergeant. Thank you, ma'am. Okay. Goodbye, Mr. Sergeant. You're going to call Mr. Young next? Mr. McKenna? Is Mr. Young your client?
Judge, I need just a moment with him.
Okay.
To hand him this plea agreement.
Please.
Sure.
And Rachel, the folks in the gallery, they're waiting for specific defendants?
With Mr. McKenna, so I'm going to get him.
Good, thank you. Okay, Rachel, you got the docket.
Okay, we'll call Jamarius Warble first.
Okay, do we need Zoom up anymore? That's getting ready to turn
Party
on.
notes should be,
Okay, you may need to do something that says after 1 minute. There you go. Thank you.
And it looks like Mr. McKinney's standing right there. We may want to pass Mr. McKinney's case for a moment.
I sent you an email, but
Okay.
yeah, we're good. But yeah, you'll need to pass it regardless to write it out.
Pass it to talk about a plea agreement with him.
Mr. Young's walking back.
Jamarius Warble, Warble's come up.
Judge, this is Jamarius Warble before the court. He's here in two case numbers, 22 CF 2320 and 23 CF 513. His mother is here in court in support of him today. Judge, it's the 22 CF 2320 case in which we're on the trial docket. That is a serious case that has a 25-year minimum mandatory on it. So I wanted the court to be aware of that as we have the discussion and we start to lead towards trial. It is a 3-count information. Count 1 is the possession of a controlled substance less than 20 grams of marijuana, a misdemeanor. Count 2 is the trafficking of fentanyl, 28 grams or more. And then count 3 is unlawful use of a two-way communications device, which is a third-degree felony.
28 grams or more?
Correct.
The docket shows 4 to 14. Are we talking about 22?
As charged in 22 CF 2320,
Yes, sir.
it is charged as a trafficking 28 grams or more.
Thank you.
That kicks in a 25 minimum mandatory if it is a plea as charged or a conviction. So I wanted the court to be on notice for that. We are ready for trial. So we would see Mr. Warble again on jury trial review.
Okay. Is the state ready to try Mr. Warble?
That's correct, Your Honor.
Mr. Warble, then that means I'll see you on Thursday at 9 o'clock. Then we'll be scheduling up the trial either the next week, a week from today, that week, or the week after that. The state has to see which cases are going to trial and how everything fits together. Mr. McKinney will stay in touch with the state and give you some idea on what that'll be, but on Thursday, we'll talk about it specifically.
Madam Clerk, I'd like 23 CF 513 to track along. It's not a case set for trial, but if we could track it on the same docket.
Thank you, sir.
Judge, this is Mr. Charlie Rhodes before the court. I'm not going to announce all the case numbers or we'll be here all day. And we've been working diligently with the state here to resolve Mr. Rhodes' outstanding cases. We've identified a list of cases which are going to be merged and dismissed. And we've identified a number of cases in which the state is going to be offering Mr. Rhodes a negotiated sentence, which I believe is going to turn into an agreement. I got a lot of those documents from the state over the weekend. I know that we've been going over this for the last week or two. So I'd like to put this on Thursday so I can go over what I've learned with Mr. Rhodes at the jail, go through a written plea agreement given the amount of moving pieces there are on his cases.
Okay. Mr. Rhodes, I'll see you on Thursday, okay?
That's not set for trial on that time. It would be just for entry of the plea.
Okay. Thank you, sir.
Mr. Warner?
Hello, Mr. Warner. Good, how are you? Your beard's getting longer.
Yeah, it is definitely getting longer.
Judge, this is Matthew Warner before the court. He's here in three case numbers, 22 CF 3120, 22 CF 1917, and 23 CF 525. Judge, this is not a case that's on the trial docket. We are working with the state to try to reach a negotiated agreement instead of going to 3 suppression hearings and 3 trials. That's something that I need a little bit more time to work through with Mr. Snell. That could be in the benefit of Mr. Warner. I know that Mr. Warner wants to be done today because he's in danger of losing a child to services. So I do certainly know that time is of the essence for Mr. Warner, but I am going to be requesting a continuance. The court has dockets as early as April 8th if we reach an agreement. If we do not reach an agreement by the end of this week, then I believe it's going to be the defense stance to go ahead and start filing motions and preparing for trial.
Okay, good.
Absolutely, I'm
I
ready
know.
to put in motions to suppress.
Good.
Like, if I don't get done with this, they're gonna adopt my daughter out, and I've never
I know.
even held her.
I know. So
How soon can we put in the motion to suppress?
if I don't have an answer this week, we can go ahead and file it and schedule it immediately.
When's the next court date?
The next court date you're going to hear from the judge is May 13th, but the next court date we could ask for would be April 8th.
May 13th is too late.
I know, but April 8th is not.
Okay.
Thank you, sir. I'll see you then.
I'll come see you probably in the week.
Wells?
You put it on 4/8?
No, I put it on 5/13, but we're going to meet and then try to resolve it and hopefully add it on to that. Judge, this is Justin Wells before the court in 3 new cases, 23 CF 2545, 23 CF 2546, 23 CF 2547, and 3 violations of probation, 19 CF 723, 20 CF 117, and 21 CF 1361. Judge, I met with Mr. Wells yesterday to discuss his options. There is an offer from the state for guidelines in his case. He's also working towards completing the program at the jail, the anchored program, and he's very dedicated to that. I'm unsure if Mr. Wells has questions for me related to whether the court could view that as a downward departure reason or not. We discussed that yesterday. So procedurally, I'm going to request a continuance. It is not a case on the trial docket, but I would anticipate seeing Mr. Wells after we have another discussion for an early plea, either to accept the state's offer or to move forward with some sort of plea to the bench. But I wanted the court to have a snapshot of exactly where we're at with it.
Mr. Wells,
Yes, sir.
you know, if you score prison, and Mr. McKinney's been talking to you about reasons for downward departure, I'm just honest with you. I'll always be honest with you. There's a non-exhaustive list, according to the statute, for reasons for downward departure. As it says, or other reasons. But the appellate courts have very frequently told the trial courts that isn't a valid reason for a downward departure outside of that list. It's non-exclusive, but it's going to be an uphill battle, you know, to go beyond those. So just listen to Mr. McKinney. Not saying it can't happen at all. I just haven't seen many cases where the courts have said, yep, that's another reason for a downward departure. So when you talk about what's happening in jail, I had to smile because there was a really good article in the newspaper about that program, and it certainly sounds very strong. I mean, it sounds good. So you'll have to listen to your attorney and decide what's in your best interest. Okay. So I'll see you back here no later than May 13th, but if you wish to enter a plea before that date, Mr. McKinney can set it for any time during April.
That would be our intention, Judge. We will do that.
Okay. So May what?
May 13th, but we can add it for an early April date after we have another chance to sit down and talk.
All right.
Okay?
Thank you.
Thank you, sir.
How are you?
Hello, Mr. Wilkins.
Yes, sir. How you doing?
Good, how are you?
All right.
Good.
Judge, this is Mr. Brandon Wilkins before the court in 24 CF 89. May I have a moment, Judge?
Sir.
Judge, in Mr. Wilkins' case, this is a new case. I did receive the discovery very recently. I reviewed it over the weekend. I have met with Mr. Wilkins since we last saw the court. I have not had the opportunity to review that discovery with Mr. Wilkins. So we do not have a resolution for today. I had put it on today in hopes that we would have a negotiated agreement. I'm going to request a continuance, and
About the bond hearing.
well, I wanted the court to know the basics for the procedure, but we did file a motion for bond for today.
Okay. For today?
Correct.
Okay, I didn't see it on the docket. And traditionally, we don't have bond hearings on docket day, but
Judge, I know that was filed by my office. If the court doesn't have it immediately access, then can we put that on Thursday so that there's notice to everybody?
is the state up to speed on the bond hearing?
I didn't realize that was on for today.
I didn't either.
Oh, well, I guess that it was probably scheduled on the next miscellaneous date. I thought it was for today. Then let's just keep the April 8th date for the bond hearing, Judge, in hopes that that gives me time to work with Mr. Snell, and in hopes that we can reach a resolution for Mr. Wilkins.
Okay. Mr. Wilkins, I'll see you on April 8th. Thank you.
Wendell Wright is next. Mr. Wright.
Hello, Mr. Wright.
Judge, this is Mr. Wendell Wright before the court. He's here before the court in 3 case numbers, 20 CF 3187, 21 CF 1772, and 20 CF 2804. The state had announced that they wanted the 20 CF 3187 case on the trial docket, which is charged as a 1-count possession of controlled substance. I met with Mr. Wright yesterday. I believe that there were some negotiation and some announcement as far as the state's offer being a concurrent sentence. I discussed that fully with Mr. Wright. The court may wish to inquire at this point of Mr. Wright, how he wishes to proceed forward. My understanding is that he does not wish to accept the state's offer, and then he wishes to proceed forward to trial.
Okay.
There were some discussions. Now, I usually don't involve the court this much into this level of discussion, but there were some discussions with Mr. Wright relating to whether or not a motion to suppress had been filed in 20 CF 3187. There has not. That's something that Mr. Wright has indicated to me when we talked yesterday, that he wishes for me to file a motion to suppress. That would obviously impact a case being on the trial docket.
Yes, sir. So do you intend to file a motion to suppress?
Mr. Wright wishes for me to.
Well, but you
And
have
that's
to
the lawyerly
determine
way to-
legally whether you can do it or not.
That is the lawyerly way to say that I have reviewed the depositions. I have requested the body camera footage from the state, and I had them resend that to me today. I have rewatched the body camera footage from the incident. If the court ordered me to do it, I would file a motion to suppress, but I would not. I don't believe that there would be a basis that I would normally file a motion to suppress in this situation.
Okay, thank you. To the state, what is the offer to Mr. Wright right now?
It's 15 years concurrent.
Okay. And if Mr. Wright doesn't accept that today, are you going to withdraw it?
Yes, sir.
Okay. Mr. Wright, do you understand that?
Judge Brown, I don't understand anything anymore.
Okay.
This court has traumatized me till no level where I can't even think anymore. Everybody's seen everything but me. I've never seen body cam footage. I've never seen anything. It's like I'm supposed to sign this or do that. Today it's one thing, tomorrow it's the next thing. One day I'm going home, next day you give me 15 years. It's I don't even know what to say. I don't even want to be in here right now, honestly. I'm just, I don't even know what I'm doing anymore. I'm just,
Okay,
it's
well, let me
crazy.
ask-
I don't.
Let me ask Mr. McKenna about the body cam footage. Has Mr. Wright seen that?
Judge, I went back through when the state announced that they wanted the 20 CF 3187 case set for trial, which was a possession of controlled substance.
Yes, sir.
And I identified that we did not have body camera footage in that case. I requested it from the state. It was provided to me. Mr. Wright hasn't seen it since I met with him yesterday. But it is a very brief amount of body camera footage that.
Okay, so will you show Mr. Wright that body cam footage between now and Thursday?
Yes, sir.
Okay. Mr. Wright, I can't make the state offer you anything. I can't make them continue to hold some offer open. The state has offered you 15 years in prison
On a third-degree felony?
on all of the cases to run concurrently for all of the cases. I understand you're at a disadvantage because you haven't seen the body cam, but again, I can't make the state hold it open.
Your Honor,
Just be
that's-
mindful that the state's going to, they say they're going to withdraw that offer today. I'm going to set your case for Thursday, and then we'll be looking at going to trial next week or the week after that on the possession of a controlled substance case.
Just that case, correct?
Just that case, yes, sir.
It's fine. I
And
understand.
for the record, that is a third-degree felony. So I wanted to make sure that that was clear on the record, that that was a global offer from the state. On the 20 CF 3187, it is a third-degree felony, possession of controlled substance with a maximum exposure of 5 years. But the state has filed a notice of HFO enhancement, which could impact and double the exposure for that case.
On a possession charge? You didn't see?
The state has filed it. I'm not saying that I agree with it. I'm just saying that I saw it in my complete review of the record.
All this happened since last night. You see what's going on, Your Honor? I mean, I study the law every day trying to fight for my own life. My family's being ripped apart by all this, and I'm not saying that I'm not without punish, don't need punishment. I'm just saying this is Your Honor, I read the law every day, and what's in the law is not what's going on in here. I mean, you guys are tormenting my family and me. I mean, this is my life y'all are taking from me. I mean, is this a game? I mean, what have I done to anybody, personal here? There's got to be something personal, because this isn't normal. I've been seeing you in the court system for a long time.
Yes, sir.
And I've never seen anything like this. I mean,
Okay.
I scored out to 30 months.
Okay.
I'm going to prison for the rest of my life. And no one seems to care. I mean, it's not a big deal here.
It is a big deal. It's a big deal that, to me, that you're on notice of what's going on. And so I understand your frustration. If that's the first time that you've heard that the possession of a controlled substance, the 5 years may be doubled, that's a big deal. So now you've heard it. We'll talk about it on Thursday. If the state still has any offer to you, then we'll talk about it then. Otherwise, we're going to try that one case. So I'll see you on Thursday. Thank you. And Mr. McKinney, you're going to show Mr. Wright that body cam footage before
Yes, sir.
Thursday.
Yes, sir, I will do so.
Good. Okay.
Can I leave? Can I go?
Yes, sir.
Show it.
Judge, this is Barry Young before the court. He's here in 23 CF 2855 and 23 CF 759, which is a felony violation of probation. Judge, we'd left this case on and trying to reach an agreement for probation or some sort of supervision. I don't think that we're there yet. I have received the discovery, reviewed it over the weekend. Since I reviewed it over the weekend, I haven't had a chance to review that with Mr. Young. Because of that, I would be requesting a continuance to the May 13th date, but obviously if we can keep hands on this and reach an agreement, I'd like to bring this back before the court.
Okay. Mr. Young, I'll see you no later than May 13th, but if the state offers you something you want to accept before that date, we have 4 different dates in April that you can appear. Okay? Thank you, sir. What about Mr. Young back here? Yep, good. Sure, Mr. Young.
Sorry about that. Judge, Mr. Young is before the court in 23 CF 1302. The agreement that's been reached is for a plea as charged. He will be adjudicated guilty. Counts 2 and 3 are misdemeanors. Is it the intention of the state for time served on the misdemeanors? So the 24 months drug offender probation would be in count 1 with special conditions of substance abuse evaluation, random urinalysis, $615 in court cost, $150 cost of defense. Judge, because the court had provided some language, I wanted the court to be able to say exactly how the court wanted it to, related to the curfew and his job. The court had suggested that the curfew for the drug offender probation not be enforced, and that probation have the ability to reinstate the curfew if Mr. Young's employment changes.
Yes, sir.
And that they have the ability to modify the curfew to fit Mr. Young to make sure that he continues working.
Good.
May I approach the plea agreement?
Yes, sir.
I would announce that it is a negotiated downward departure. Stay right here.
Mr. Young, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down.
May I approach the plea
Yes, sir.
agreement?
Please. Thank you, sir. Okay, so the unique language, where is that?
I didn't write it in there because I wanted the court to be able to announce it how you wanted it. That's why
Okay.
I can write it in there if the court would like. I didn't want to write the wrong thing. because the court certainly has the ability to control that language. Wait, it's only be a second.
Traditionally, what are your hours at night?
Typically, it's 7 p.m. to 7 a.m., or his
No,
work,
his
his work
job.
is, I'll let him answer.
10 to 6 a.m., 10 p.m. to 6 p.m.
Thank you.
6 p.m. to 6 a.m.
6, I work at 10 at night to 6 in the morning.
Thank you.
That's better.
Yeah.
Okay, so what about language similar to this? Curfew of 7 p.m. to 7 a.m. is stayed and not enforced and not required as long as probation previously acknowledges that defendant has a job from 10 p.m. to 6 a.m.
I think that's fair.
In the nights that he's not working, that would be effective. But it's only the nights that he works, right?
Right.
And I guess he would provide the work schedule to probation, that's how they determine that.
Yeah, that's fine.
So curfew of 7 p.m. to 7 a.m. is stayed and not required on the nights probation previously acknowledges that defendant has a job from 10 p.m. to 6 a.m.
Correct.
Is that okay? I'll let you write that in, because my writing, you will not be able to read it. And I'll read it to you slowly if you wish.
Yes, please.
Curfew of 7 p.m. to 7 a.m. is stayed and not required on the nights probation previously acknowledges the defendant shall work from 10 p.m. to 6 a.m. Probation, you okay with that language? Thank you, sir.
You told him to stay in Milton, right? I'm staying in Okaloosa County.
Yeah.
So, Mr. Young, if you agree to that, if you'll initial it.
And to probation, he lives in Milton, so it will be a transfer over to Santa Rosa after he reports here for the first time.
Mr. Young, did you read the plea agreement? Is that a yes?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
So I'm going to initial. I'm going to have Mr. Young initial, and I'll have Mr. Snell initial. And you know that you have to provide a work schedule.
Yeah, I got the schedule on my phone.
Okay, thanks.
May I approach?
Yes, sir. Thank you, sir. And it says 24 months. What is, looks like it says DOP.
Yes, drug offender probation.
Thank you. Mr. Young, I do accept your plea. First off, did you understand that's what
Yeah,
DOP
drug offender
meant?
probation is just a curfew and a random year and absence.
Okay. You're sentenced to 24 months drug offender probation. Special condition, you'll need to submit to substance abuse evaluation. If any treatment's recommended, begin that within, well, the substance abuse evaluation within 30 days from today. And if any treatment's recommended, within 60 days from today. Submit to random urinalysis, not have any drugs or medications without a valid prescription. You'll need to pay the court cost, $150 public defender's fee, $40 per month cost of supervision, and then the curfew as I previously stated. Mr. Young, I wish you the best, sir. Thank you.
Thank you. Probation?
Your Honor, real quick, there was time certain on misdemeanors, correct?
Yes, sir. I'm sorry. Thank you.
Judge, this is Ms. Carol Worley before the court in 23 CF 2527. What I was explaining to Ms. Worley is that I have reviewed a report prepared by Dr. McDonald. That report finds Ms. Worley incompetent to proceed and recommends placement at the Florida State Hospital. Has the court had the ability?
I have, and with the belief that I will see Ms. Worley back here in about 6 or 12 months, right?
That is what the report said, Judge, that it is expected that she be restored to competence and be brought back within 6 to 12 months.
Does the state have any objection to that report? Ms. Worley, I do find at this point that you're incompetent to go forward with your case. And so you'll go to the Florida State Hospital, and then hopefully I'll see you. I rotate out of this division at the end of this calendar year, but I hope I see you before the end of this year. Thank you, ma'am.
Okay.
Rachel, you know that Mr. Noakes is also.
I'm innocent.
Good.
I know that.
Good.
Well, apparently you don't because.
Okay, thank you.
I have to go to a hospital and go right to about the jail.
Once you're deemed competent to proceed, then they would bring you
I
back.
am competent.
I didn't make that decision.
Well,
Thank you, Ms. Worley.
Miss Worley? Miss Worley? Come on, Miss Worley, this way. Chelsea Young is next.
Hello, Ms. Young.
Yeah. Judges, Ms. Young is before the court on new cases and felony violations of probation. We had left it on this docket because Ms. Young wishes to try to resolve these matters. I still need more time to work it through with Mr. Snell. We don't have that wrapped up for today.
Okay.
So I'm going to request a continuance until May 13th, but I know that we're going to try to resolve this much earlier than that.
Good. So, Ms. Young, I'll see you no later than May 13th.
Okay.
But we have 4 different dates in April that Mr. McKinney can bring you back if the state offers you something that you think is in your best interest to accept. Okay?
Okay.
Thank you, ma'am. Good. Ms. Shelby is coming next, Mr. Noakes. Thank you. Hello, Ms. Shelby. Mr. Noakes is on Zoom, just so you know you're not alone.
Sorry, that scared me.
Didn't mean to scare you.
It's okay. How are you doing?
Doing well, how are you?
I'm good. Trying to stay out of trouble.
Good, good. Mr.
Your
Noakes?
Honor, Dr. Harper called me, I can't remember, it was, I think maybe Thursday of last week. She said that she had met with Ms. Shelby and her recommendation was going to be Phoenix House. And so I'm trying to get that in, get the contact information for Phoenix House to ask them to go see her, but she indicated the report would be done to me fairly quick, so I think it might just be best to continue it until we get that report.
Okay. So, Ms. Shelby, what I'll do is, just as a backstop, I'll see you no later than May 13th, but Mr. Noakes, if he gets that report from Phoenix House and is ready to come before the court, I can see you first, second, third week of April, okay? Then.
Okay. Thank you.
ma'am.
Have a good day.
Yes, ma'am, you too.
Lori White, is next.
Thank you.
Bye, Mr. Noakes.
I'll see you.
Thank you.
Good morning, ma'am. Or, I'm sorry, good afternoon. Mr. Noakes is on Zoom, just so you know. Okay. Thank you.
So, Ms. Wysack's case, Judge, we asked it to be set for trial, and that's our position at this point.
Okay.
I will tell you, I heard from Mr. Anchors at the state attorney's office the other afternoon. He told me that him and Mr. Snell were meeting and working through, and maybe there was going to be another offer, but I hadn't heard anything, so.
Mr. Snell, are we heading toward trial?
We have our subpoenas out, Your Honor. I've got to make a phone call to the officer involved, and if, once I've talked to him, I can extend it to a different offer, but I have to talk to him first.
Okay.
So that he will be hearing from me.
So I'll see Ms. Wysack back here on Thursday, and if you don't offer her something that she wants to accept, then we'll be going to trial the next week.
Yes, sir.
Yes. Ms. Wysack would have that.
I'm sorry, we couldn't understand you, Mr. Noakes.
That's what Ms. Wysack requested.
Okay. So, Ms. Wysack, I'll see you on Thursday.
Thursday.
Okay?
Thank you, Your Honor.
Thank you, ma'am.
Thank you. Thank you, Martin.
Javier Samuel.
Judge, I'll wait for him to get out.
Yes, sir. Hello, Mr. Savia.
How you doing, Judge?
Good, how are you?
I'm all right.
Mr. Noakes is on Zoom, just so you know.
Your Honor, on Mr. Sabia's case, the court will remember we tried a case over the summer, late fall. We've already gone through the sentencing on that case, but the court gave him youthful offender. This case had been going right in the same both all the way up to trial with the other case, and then it just kind of fell off the docket and it didn't reappear, and I mentioned it the other day at pre-trial, so that's why it's back on the docket. What I would suggest and what I told the state is if we could continue it to May 13th, and obviously if the state's willing to make a concurrent offer or some other option for us, we can always bring it back, but I just didn't want it just to fall under a rock and stay gone.
Right, sure. So, Mr. Sabio, Mr. Sabio, I'll see you no later than May 13th, but if the state comes up with something like a concurrent sentence, then I'll see you before that.
Okay, yes, sir.
Thank you, sir.
Yes, sir.
Jessica Robinson, Mr. Cox.
Judge, I believe that's all I've got. I'm going to check out.
Sounds good. Thanks, Mr. Nopes. Wait. Mr. Nopes, hold on. Madam Clerk says, is this
What did you send
Anthony
it?
Lucy was not transferred? Okay. So, Mr. Lucy, 23 CF 736 was not transported, but it was supposed to be on the docket for today. What do you wish to do with his case?
He's got a new case over in county court, and I think he may even have another one coming to county court. But Judge Mason today was aware of all that, and aware of your case. She had already, there was something going on in vet court, so she's added him to the docket for Friday at vet court, just to see if the state's willing to let everything go to vet court or what have you.
So do we want to continue Mr. Lucy's case to May 13th?
I think that would be in the best interest, Your Honor.
That's probably the best thing to do, just keep up with it.
Yes, sir. And then just
Fine to do that, we'll put it on May 13th with the understanding, of course, if we get something else worked out, we can always bring it back early.
Absolutely. Thank you. Madam Clerk, anybody else? Thanks, Mr. Nopes.
Thank you, Judge.
Yes, sir, you're welcome. Okay,
Jessica Robinson, Judge.
thank you. Hello, Ms. Robinson.
Your Honor, Ms. Robinson, if we can keep her set for this Thursday. It is set for trial, but it looks like we were going to be able to resolve it, but I still want that option to reach out to the alleged victim in this matter.
Okay, has the state sent subpoenas for Ms. Robinson?
Yes, this was, yes, sir.
Okay, because I didn't have it down for, oh, this is not Dino.
It's, okay.
This is Jessica.
Then that's not the one that I said something.
Well, that's what I was curious
Yeah,
about.
you're correct.
Okay.
Wait, so you did or did not send
No,
something?
this was not one of the ones.
Jessica Robinson, I didn't have it down for trial.
Judge, if it's possible, could we still put this on the Thursday docket
Sure.
for a resolution? Just
Yes,
because
sir.
I feel like we're close.
Okay, so, Ms. Robinson, I'm just going to put it down as a backstop for May 13th, but that's just if it's not resolved on Thursday.
Okay.
So I'll see you on Thursday for status.
All right, thank you.
Thank you, ma'am.
They're going to bring you over, so I'll see you Thursday too.
Jennifer
I'll see you
Sharman is
Thursday.
next.
Okay.
Yep.
Yes. Hello, Ms. Sharman.
Hello.
Good afternoon, Ms. Sharman.
Hello.
Your Honor, we're here on two case numbers. The 23 CF 1665, that's the one with the outstanding FDLE report. It's a felony cannabis charge. I did file a motion to compel back in January 22nd, but I didn't secure a hearing time yet. I'll just see if the state's going to move forward with the. Okay. Your Honor, it looks like they're going to move forward. If we can set this for a motion to compel.
Okay. Do you need it in the afternoon, or do you want it in the morning?
Your Honor,
How long is it going to take?
I don't see this being that long. About 20 minutes.
Why don't we set it for April 11th at 9 o'clock?
Okay.
That is in 23 CF 1665. And then in 23 CF 2506, we're set for trial, correct?
We are, Judge. The issue is with we're done with depositions. I am ready in that 2506 case number. Just that 1665 with the motion to compel, with that charge to get it off her score sheet, I'd be in a different position to negotiate for that sentence on the newer charge. Is it possible to, because we've got the motion to compel on the older case, I don't want to set that one for trial, the newer case. Could we push that to May 13th till we resolve the...
To the state, what do you want to do? If you say you want to go to trial, we'll go to trial. If you say you'll wait, then we'll wait.
Regardless of the outcome of the first case, the state's recommendation or offer on 2506 isn't going to change.
Okay, so we're going to trial? Okay. So, Ms. Sharman, I'll see you back here on Thursday. We'll be looking at going to trial on the missile into a dwelling charge and criminal mischief either next week or the week after that.
Okay.
So I'll see you Thursday.
Thank you.
Thank you, ma'am.
I'll see you.
Okay.
Yep. You're welcome.
Thank you. Hello, Ms. Smith.
Hello.
Yes. Your Honor, we're here in 24 CF 134. My client, the current offer, Your Honor, is 1129 County Jail. I did provide counters for 3 years probation. I went over your lack of criminal history, but currently right now as we stand, it's 1129. I'm asking for a first-time continuance to 513 for the next pretrial.
Okay. So, Ms. Smith, I can't make you accept anything. I can't make the state offer you anything. So all I can make you do is ultimately go to trial. Your attorney's not ready to do that yet, so I'll see you back here no later than May 13th. If the state offers you something between now and then and you want to accept it, Mr. Koch can set it for a hearing in April, okay?
Is there any way I can get a bond reduction or something? I've been in court, in jail today makes 60 days that I've been in Okaloosa County. And I also have a co-defendant on this case who just, well, I have
Ms.
a
Smith,
family to get back home to, a child.
And I understand 60 days is an infinite amount of time in jail.
Right.
If Mr. Koch has any valid reason that he can file a motion for bond reduction, then he can do that. 60 days in the eyes of the court is not, it's not a huge period of time as far as just the passage of 60 days in the Okaloosa County Jail isn't going to be a reason for a significant change in circumstance to grant a motion to change bond, just so you know. But Mr. Koch may have other reasons to file it, okay? And if he does, then I'll see you before May 13th. Thank you, ma'am.
Will you be able to come see me?
Yes.
24 CF 134.
Yes.
Yes, sir. Hello, Mr. Bolt. Good, how are you?
Tristan
I'm
Polk.
good.
Ken Ford. Your Honor, we're here in two case numbers, the 22 CF 3110 and the 23 CF 1969. Your Honor, depositions were set for the AV. She did not appear, but she is in custody in the Okaloosa County Jail. I spoke with Mr. Gomez. He would like to set the VOP, the 22 CF 3110 case, for trial, but he did tell me he's going to speak with the alleged victim at the county jail, leave negotiations open. My client does not score prison, so I feel that resolution is close, but Mr. Gomez does want to set the VOP.
Okay. Mr. Gomez, how far out do you want to set the violation of probation?
If I'm not mistaken, I think I heard a 4. If I could have that date, just because I anticipate having my big trial that second week, so just like a little bit of time to prepare for that. So if we could do the
Good, okay.
that would be 4:15 in the afternoon.
At 1:30, yes, sir. So, Mr. Polk, I'll see you no later than April 15th. If the state offers you something that you want to accept before that date, Mr. Koch can set it as early as April 8th. Okay, thank you.
Page Pritchard is next.
Thank you.
Okay.
Hello, Mr. Pritchard.
Okay. Your Honor, if I may just have a brief moment.
Yes, sir.
I know. Your Honor, this is Mr. Pritchard in 23 CF 1830 and 23 CF 2718. This will be a change of plea. And I'll start with the count 2 of the 23 CF 2718. That will be adjudication of guilt and credit for time served for that misdemeanor. Now in 2023 CF 1830, count 1 and count 2. And in 23 CF 2718, count 1. Be adjudication of guilt, 1 year of the drug offender probation, which has a curfew of 7 p.m. to 7 a.m., followed by 3 years of standard probation, $40 per month cost supervision, $615 in court costs, $100 for the cost of prosecution for the VOP, $250 in defense costs, substance abuse evaluation within 30 days, and any recommended treatment within 60 days. There'll be the random urinalysis, random breath test, no possession of drugs without a valid prescription, no possession or consumption of alcohol, gainful employment or 5 job applications per week, and there's 24 hours of community service. If I may approach the plea form and score sheet.
What about count 3 of 23 CF 1830? Previous, okay, thank you.
May I approach, Judge?
Yes, sir. Mr. Pritchard, if you'll raise your right hand, thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down. Mr. Pritchard, are you currently under the influence of any drugs, alcohol, or medication?
No, Your Honor.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No,
Mr. Pritchard, did you read the plea agreement?
I did.
Do you understand it?
I do.
Did you discuss it with your attorney?
I did.
Did he answer all of your questions?
You did.
Are you satisfied with his representation?
I am.
Did you sign the plea agreement?
I did.
Mr. Pritchard, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served in count 2, 23 CF 2718. You're sentenced to 1 year drug offender probation in the other counts. You have a 7 p.m. to 7 a.m. curfew. It's followed by 3 years of standard probation. You need to pay the $40 per month cost of supervision, pay the court cost, $100 VOP fee, $250 public defender's fee. There's also court costs in the new case, correct?
Correct, Judge.
You'll have no drugs or medications without a valid prescription, not have any alcohol, not consume any of those. You'll need to submit to a random breath test, random urinalysis. You will need to submit to a substance abuse evaluation within 30 days from today. If any treatment's recommended, begin that within 60 days from today. You need to obtain gainful employment or perform 5 job applications per week. Perform 24 hours of community service work. Thank you, Mr. Pritchard. Good luck to you, sir.
Thank you.
Best of luck.
Harris Fryer is next.
Judge, if I have a brief moment,
Yes, sir.
please.
Probation, why couldn't you help that lady use hers?
Oh, boy.
On Mr. Pritchard's case, Mr. Koch, his prior supervision was revoked and terminated?
Correct, Judge.
Yes, sir.
Yes, thank you. Sorry about that.
No, thank you. Thank you, Madam Clerk.
Your Honor, we're here with Mr. Paris Pryor in 23 CF 95. I left him on today to hopefully work out a deal. We recently appointed. Unfortunately, the counters weren't agreed to, so if we can put this on the 5/13 pretrial.
Okay. Mr. Pryor, I'll see you no later than May 13th.
Yes, sir.
Thank you, sir.
Derek Pugh next.
Thank you. Hello, Mr. Pugh.
How you doing, sir?
Good. How are you, sir?
I'm all right, Judge.
Good.
Your Honor, if I could have a brief moment.
Yes, sir.
Derek. Right there. Excellent. Your Honor, this is Mr. Derek Pugh in 23 CF 2454. This will be a change of plea. I first want to mention count 1. It's going to be the lesser included trespass misdemeanor under Florida statute 810.08 subsection 1. So for count 1, it'll be adjudication of guilt, credit for time served. Count 2, charged as is petty theft. It'll be adjudication of guilt, court costs, $150 in defense costs. There's $200 in restitution to Carlos Carrillo Principe, and my client will be placed on 1-year probation, which will automatically terminate upon payment of that restitution. If I may approach with the plea.
Yes, sir. Thank you. Thank you, sir. Mr. Pugh, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Pugh, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Pugh, I do accept your plea. You're adjudicated guilty to the lesser included offense in count 1, as charged in count 2. You're sentenced to time served in count 1, sentenced to 1-year probation in count 2. You'll need to pay the court costs, $150 public defender's fee. You'll need to pay restitution in the amount of $200. Your supervision will automatically terminate upon your successful completion of probation, which means the payment of that money, as long as you haven't committed any new law violations.
Yes, sir.
Mr. Pugh, how much money do you make per month? And the reason why I ask that is there's a $40 per month cost of supervision, and if that's going to be really tough for you to pay, then I'll waive it.
That'll be tough, sir.
Okay, well, tell me how much money you make.
I just had started the job when I was out at an oil change place.
Okay. What have you averaged making per month for about the 5 months before you went into jail?
Well, like 100.
100?
Like $100.
Okay. I do waive the cost of supervision. So if Mr. Pugh pays the $200 in restitution but doesn't pay the court cost and the attorney's fees, his supervision's going to terminate and those are going to go to civil lien? Or does he have to pay those two amounts in addition to the restitution before his probation will terminate?
Your Honor, it's my understanding just the restitution, but I will defer to, is it My understanding is just the 200 restitution, once that's paid,
Yes.
probation's terminated, court costs and defense fees can go to the lien.
That's correct, Your Honor. We're mainly concerned about the restitution.
Good.
Thank you.
Thank you, Mr.
So I'll be
Pugh.
going home today, sir?
Yes, sir, they'll let you out today.
Thanks.
Thank you. Thanks.
Hayward Reeves,
Good afternoon, sir.
Your Honor, I have Mr. Hayward Reeves in 23 CF 2045. The depositions were scheduled. The alleged victim was served and failed to appear for those depositions. So I asked the state if they're going to move forward.
At this time, Judge, the state would null cross 23 CF 2045.
Okay, Mr. Reeves, your case is dismissed.
Best of
Thank
luck.
you. I'm
Thank
going
you, sir.
home.
Yeah, best of
Yes,
luck.
sir.
God bless you guys.
Excellent. Your Honor, if I may have a brief moment?
Yes, sir.
Please. I wrote out a new plea form.
Yes, sir, probation.
Your Honor, thank you.
Okay.
Oh, I'm sorry.
Mr. Gomez, for Mr. Pugh, is it okay for JCS probation? JCS supervision?
Let me ask you this, can the court, probation, hold on one second. Can the court waive the cost of supervision at JCS? I don't think I can.
I don't know the
cannot.
answer to that question.
I don't know the answer to that.
I don't think I can. So, Mr. Pugh,
Financially benefit him.
it'd be $50.
Him to be on state probation, I believe.
Right.
So leave them on.
Yes, sir. Please. Thanks, Mr. Pugh. Okay, yes.
Yes, Your Honor, I have Mr. Jonathan Romero. Oh, I apologize, still need your signature. Yep, and today's 18th, but this will be a change. 318.
Yes, sir.
Yes, Your Honor, this will be a change of plea, no contest. For count 1, it will be a withhold of adjudication. 180 days, Okaloosa County Jail. My client will receive credit for all time he has served. This will be followed by 36 months of probation. 515 in court costs, 150 in defense costs. Must maintain gainful employment or 5 job applications per week. And if I stated that's count 1, that will be a withhold. Count 2 will be adjudication of guilt and credit for time served for that misdemeanor.
There's a restitution amount for count 2 that I need to make sure is correct.
Okay. We'll put that in count 1. This will be in probation.
Mr. Romero, while they're doing that, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down.
I'm sorry.
Actually,
600. $79.44. It's the Pelican Beach Resorts. Unit number 1211.
Your Honor, I did add an additional, the restitution will be $679.
I have paid for that already.
You've already paid for the restitution?
Yes, sir.
Okay. Then you just show proof of that.
Okay.
Do you understand?
Yes, sir.
Okay, no questions? Okay. Your Honor, if I may approach with the plea form and score sheet.
Okay, yes, sir. Mr. Romero, so did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
So this is a downward departure?
Yes, Your Honor.
Mr. Romero, so the two things, one that was not in the written plea agreement was you'll have to pay $40 per month cost of supervision. Do you understand that?
No, sir. What does that mean?
It's what everyone pays, well, just about everyone pays when they're on probation.
Okay.
It's a $40 a month charge, okay? And Mr. Koch just didn't have that in this agreement, so I wanted to make sure that you understood that's also required if you enter this plea and I accept this plea. Do you understand that?
Yes, sir.
And then the other thing that they were just talking about, the restitution in the amount of $679.44. You said you've already paid that?
Yes, sir.
So I'm going to say that has to be paid, but you only have to pay it once. If you've already paid it, then you just show probation proof of that.
Okay.
Okay? So, Mr. Romero, I do accept your plea. Adjudication is withheld in count 1. You're adjudicated guilty in the misdemeanor. Count 2, sentenced to time served. You're sentenced to 180 days in the Okaloosa County Jail with credit for all time served in count 1, followed by 36 months of probation. You'll need to pay the court cost, $150 public defender's fee, $40 per month cost of supervision, obtain gainful employment, or do 5 job applications per week. You'll also need to pay the restitution, the amount of $679.44. If you've already paid that, then you'll just have to show proof of that payment.
Yes, sir.
Thank you, sir. Good luck to you.
Thank you.
Brandon Roswell.
Your Honor, if I may have a brief moment. Yep. Your Honor, I have Brandon Roswell with me. I was explaining to my client, I set him, or kept him on today because we recently got the FDLE back, and one of the substantial amount of an unknown substance came back non-controlled substance. So I was hoping to maybe work out an offer. Unfortunately, I wasn't. If I can put him on the 513 pretrial, and I explained to my client, if we do get a resolution, I can absolutely bring him in earlier.
Good. Mr. Roswell, I'll see you no later than May 13th.
Thank you, sir. Bless.
Yep.
Hello, Mr. Rhodes. Please come to the window. Thank you, sir. Yes, sir.
Your Honor, I'm seeking a first-time continuance in this matter, and if we can set this for 513 pretrial.
Okay. So between now and May 13th, what are you going to do on Mr. Rowe's case?
Your Honor, if I may approach.
Okay, sure.
We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at dacetirepros.com. Tire pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
And I'm granting a continuance, so that means that I'll see you on May 13th.
May 13th.
No later than that, but Mr. Koch is probably going to set a hearing before that date, and I'll see you then, okay?
All right, yes, sir.
Thank you, sir.
Anything for me?
Nope, you're good. It's all right.
Is this okay to take mine?
No, we have to leave that. Just follow the deputy. She'll take care of you. Thanks, Mr. Rhodes. Let me talk to you about this one. Your Honor, may I just have a brief moment?
Yes, sir.
Judge, thank you. I got Mr. Nathan Runyon. Your Honor, if we could set this for the 5/13, we're looking for a placement for my client for part of the offer, Your Honor.
Okay. Mr. Runyon, I'll see you no later than May 13th.
All right, thank you.
Thank you, sir.
All right, thank you. All right, Nathan. Hi, Thomas.
Hey, Mr. Tom.
Good, good. Your mom was here earlier.
She was?
Yeah, she had to leave though. Okay.
I see.
Your Honor, if we could continue this to the 5/13
Okay.
pretrial,
And I see my note.
and just
There-
to
We still haven't gotten an evaluation back.
know, and just to inform the court, my client, his mother was here, and she did bond him out. He did get arrested on a new charge that was ultimately dropped, but I still have an evaluation for my client.
Okay. So, Mr. Sharp, I'll see you no later than May 13th, but if Mr. Koch gets that report, then I'll see you before that. Okay?
What report?
No later than May 13th.
I'll talk to you about it.
Okay, thank you.
Y'all do know that.
It's okay.
I'm bringing the vehicle back.
Ruben Stokes is next.
Thank you. Hello, Mr. Stokes.
Judge, how are you?
Doing well. How are you?
I'm blessed and highly favored.
Yes, sir.
I was born blessed.
I
Just
agree.
didn't know it.
I'm sorry?
I just didn't know it.
Yes, sir. I agree. We have a lot of blessings.
I don't know if you know, but the pod that I'm in, we've been posting in the newspaper.
For the class?
Yeah, I have the original
I
here,
did.
but
I read that. I talked about it earlier today.
this is my
Congratulations.
certificate for phasing up, phase one.
Excellent. Yes, sir. Thank you.
Your Honor, could we briefly approach?
Yeah. Look at his certificate. Isn't that neat?
I got you.
That's awesome.
Actually, we'll just, on the record, Your Honor,
Okay.
just to,
Sure.
because this was the first phase, correct?
Mm-hmm.
Gotcha.
I'm also told that I can finish up the program outside. It won't cost me anything, and they're willing to help me find a place to live other than where I was going.
Okay. Yes, Your Honor. My client is flourishing with this faith-based program they have.
Yes, sir.
He's real passionate about it. Currently, Your Honor, it's a guideline sentence.
Which is what? DOC?
Oh, yes, DOC, it's like 53 months.
Okay.
Without the violation of probation points on there, which I haven't had, he scored up 52.05 months.
Okay.
And we did complete depositions, Your Honor. We spoke with the AV. The counteroffers I did convey to the state, and at this time, they are not accepting our counteroffers.
That's fine.
Your Honor, I was just speaking with the state on your, are you showing trial or plea?
Yes, sir.
And I was asking if we could keep this set for Thursday.
Okay.
Then I could talk to my client about some options of course trial, but other options we have, because right now they're not accepting our counters, and it's a substantial guideline sentence.
Yes, sir.
So if we can keep this set for Thursday,
Okay.
and I can talk about some options with my client.
Okay. So, Mr. Stokes, I'll see you on Thursday. If it's not resolved then we'll be going to trial the next week or the week after that.
That's fine.
Thank you, sir.
I don't want to take your only copy. Is this your only
No,
copy?
I have the actual
Okay.
original.
I'll see you this week.
But that's not what you told me. You said they were coming over.
The counters.
The three years.
It's correct. I gave him those counters. The program, the conditions, I'll talk to you at the jail, but at this time, they're not accepting any counters or staying with the guidelines.
All right, when you coming?
This week, because they're coming to court Thursday.
All right.
All right, thank you.
Next, I have Brian McKinney with Mr. McKinney.
Hello, Mr. McKinney. Good, how are you?
Great. Judge, this is Brian McKinney before the court in two case numbers, and I'm standing in for Mr. Kleins today.
Because otherwise it'd be a conflict, right, because of the names?
I don't know if it arises to a level of a conflict, but we'd have to wrestle over who the McKinney is in the room.
Yes, sir.
But I met with Mr. McKinney at the jail yesterday. We discussed his case fully, so I believe I'm up to speed enough to advise him on the plea agreement that we're about to enter with the court.
Okay.
We've reached an agreement with the state that is a negotiated downward departure that related to the need for restitution. The agreement that's been reached is a plea as charged. To the state, if we're addressing the misdemeanors, are those time served?
The misdemeanors would be time served, Your Honor.
And on the felony counts, it would be a concurrent 3 years probation with special conditions of 24 hours community service work, shoplifters awareness course, no trespass at Walmart. I wrote no trespass at Walmart in here twice. I guess I wanted to make sure that I conveyed that. No trespass at 807 Playground Road, Fort Walton Beach, 32547. And a $1,000 restitution amount to Ronnie Oglesby, spelled R-O-N-N-I-E, last name O-G-E-L-S-B-Y. Also, no contact with Ronnie Oglesby, and he is the individual at the 807 Playground Road, Fort Walton Beach, 32547 address. Standard court costs would be $515 in each case, a total of $250 cost of defense.
And $40 per month?
Yes, Your Honor. And in looking at the agreement, it's not written in, but there would be a $40 a month cost of supervision. I would request that the court consider waiving all or a portion of that, given the amount of restitution of $1,000 for Mr. McKinney. May I approach?
Yes, sir.
I guess I need to make sure that Mr. McKinney has no additional questions, and then he would need to execute the document. Do you have any questions?
Sir.
For the record, Your Honor, I had spoken with the victim, and we agreed with that departure based on the need for the restitution paid to that victim, Your Honor.
Okay, thank you.
3/18/24. Are you going to be staying in Fort Walton? Where in Fort Walton?
Yes, sir.
To probation, he's going to be staying in Fort Walton. May I approach the plea agreement?
Yes, sir. Mr. McKinney, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
Thank you, sir. You can put your hand down. Mr. McKinney, did you read the plea agreement?
Yes, sir, I did, Your Honor.
Do you understand it?
Yes, sir, I do, Your Honor.
Did you discuss it with your attorney?
Yes, sir, Your Honor.
Did he answer all of your questions?
Yes, sir, Your Honor.
Are you satisfied with his representation?
Greatly, sir, greatly satisfied, Your Honor. Thank you, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. McKinney, I do accept your plea. This is a downward departure. On the misdemeanor counts, you're sentenced to credit for time served. On the felony counts, you're sentenced to 3 years probation. You'll need to perform 24 hours of community service work. Enter and successfully complete the shoplifters awareness course. Have no trespassing. Is it at any Walmart? Traditionally, they ask for all Walmarts, not the.
I would say just that one.
Okay.
Because I think that's a
No
little bit
trespass at
rough.
the Walmart on Beale Street in Fort Walton. Also, no trespassing at 807 Playground Road in Fort Walton Beach. Need to pay the $1,000 in restitution. No contact with Mr. Oglesby. You need to pay the court cost, total of $250 public defender's fee, and $40 per month cost of supervision, but let's talk about that a moment. Mr. McKinney, how much money have you averaged making per month?
I get $914 a month Social Security disability, sir.
Okay, I do waive the cost of supervision. Okay?
Thank you.
So you don't have to pay that. Mr. McKinney, I've seen you frequently.
Yes, sir.
I'd rather see you out on the street
Yes, sir.
than in here anymore, okay?
Yes, sir. I
Thank you,
promise.
sir. Good
Thank
luck
you.
to you.
Thank you, Your Honor.
It's adjudicated guilty.
Yes, ma'am. Good luck. Yes, ma'am. Adjudicated.
Thank you, Your Honor.
Yes, sir.
Has a few, probably that are Mr. Klein's cases. That would be good. That's a PTI agreement, if we could leave it on Thursday.
Yeah, if we can just have it on for Thursday, I'm gonna be sending the pizza over to Mr. Klein, and we should be getting it. I just wanna, I'd like to leave it on for Thursday, because it just helps me remember to make sure I get it.
And we've had contact with Mr. Neal. I would waive his appearance today. That's also going to be a PTI. Mr. Pinnell is in his mid-80s. He lives in Atlanta. So we're trying to accomplish a PTI. And I believe that he has mailed back the document. I'm just unsure where he's mailed the document to. So we're trying to accomplish that paperwork. If we could leave him on jury trial review, we should be in a better position for Mr. Kleins to inform the court.
Do we want him to appear via Zoom? Are they gonna bring him next time in the restraint chair? What's gonna happen?
I just think it was a legal issue today.
Okay. Okay. Wasn't one where he's, because I had somebody that didn't appear 2 days in a row, and they said it was the third day for first appearance. And I said that, but that's not on this case. So are we going to, we're gonna set him for Thursday for status, or?
Your Honor, I was going to announce that we had depositions and the alleged victim did not show, and then I was going to ask the state if they were moving forward on it. Benjamin Steen, S-T-E-E-N.
Okay.
I guess
So
I
you're
meant.
seeking a continuance on Mr. Steen?
Yeah, the victim's Holiday Inn. Yeah, they're here.
So continue it.
Yeah, they're the ones that are out the $7 grand or whatever it was.
So we'll continue. continue. Judge, if we could continue and
Yes,
try to serve the AVs again, Judge.
okay, yes.
We'd like them both to try.
Yes, that's great. Yes, ma'am.
And then Thursday, then Thomas Lowry, he did show last week, he had written some correspondence to you today, asking minutes Thursday.
Okay. What does the state seek?
KP, Your Honor.
KPs will be issued for Mr. Lowry, and the first appearance judge will determine the bond. That's it. Thanks, everyone. Thanks, everyone, for a hard day at work. Mr. Cummings, if